And Stephen said, where'd you put the clock? Did you have any reaction?
No, no.
Have any reaction to that?
I hear that a lot, so it's not, that's nothing special. Okay, let's see.
I got a free shot.
That one's trash. Yeah, this one's now. Has anybody got an extra pencil over there?
But what it was the regulation.
Sorry, I don't.
That's all right.
Yeah.
Which made me think I've got one.
There we go. Thank you.
It's better and it's.
I like that one.
No, walk out with that one.
Yeah.
That old shop in the local people. The new one.
There's the clock.
Got the one.
You know, actually, I guess I can see why.
That was a little fast.
It happens because they're always, you know, going like this, but I don't see them doing that with their back.
Yes, sir. I got it, thank you very much. I put it in my car so I couldn't forget to take it home.
Okay, good.
I did know that. I did know that.
Everything good?
Chairman.
Lots of new faces. Glenn, did you know that Bobby Maxwell passed away?
Oh, yeah.
We went up to the viewing center.
Were you there?
Lots of faces that you would have known.
No, I was away. I just got back today. Yeah.
It was like going back in time.
He was a good person.
Yes, he was.
We'll do the consent agenda.
Sure.
Good afternoon, everyone, and welcome to the October the 6th Delaware Public Service Commission meeting. It's nice to see people in person, even with masks on. We have a reading of the meeting minutes of September 15th, 2021. Does any commissioner have any changes or corrections to be made to the meeting minutes? If not, Commissioner Gray.
I move that we adopt the minutes as submitted.
I second.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 And Commissioner Correa is absent. He had a procedure yesterday. Hopefully it went perfectly. He'll be back here at our next meeting. We have the consent agenda. Anybody will wish to take a matter off the consent agenda? If not, Commissioner Drexler.
Mr. Chairman, I move that we adopt the consent agenda as presented.
I second.
Any discussion on the motion to approve the consent agenda? Hearing none, all those in favor signify by saying aye.
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 4 ayes and 1 abstention, or 1 absentee. Okay, we're going to get to the regular agenda. Number 1 is in the matter of the application of Artesian Wastewater Management, Inc. for a certificate of public convenience and necessity to provide wastewater service. And we have the application and proposed order 9895. And
Mr. Chairman, I apologize. If I could just remind people to use the microphone so that we can all be heard, that'd be great. Thank you.
So we have Mr. Walsh from staff.
Thank you, Chairman and Commissioners. We have again addressed this docket for sake of pushing it forward one more time. We have the agreement of Artesian Wastewater Management, Inc., as well as the town of Milton, which filed an opposition. And this is for an additional 30 days, which is pursuant to 203D G1, and we will set this with your approval for October 27th. The parties are still working out some issues that may resolve the opposition of the town of Milton.
Thank you, Mr. Walsh. Ms. Iori, I assume that's correct?
The DPA has no involvement in this matter, Chairman Winslow, thank you.
Okay. And Artesian agrees, so that's not necessary for you to come up front. Commissioner Conaway,
Move that we adopt proposed order number 9895 as presented.
I second.
any discussion on the motion? All those in favor signify by saying aye.
Aye.
4-0, one abstention. Thank you, Mr. Walsh. And number 2 is in the matter of the application of Delmarva Power and Light Company for an increase in electric base rates and other miscellaneous tariff changes. And we got, I believe, Brian Jordan is here, or?
Good afternoon, Mr. Chair, Commissioners. Can you hear me okay?
Yes, we can.
All right, very good. My name's Brian Jordan. I'm here on behalf of Delmarva Power and Light Company. And, Your Honors, Delmarva Power is asking that the Commission reconsider the reprimand and the remediation, or the reprimand and the remediation plan that is contained in paragraphs 2 and paragraph 3 of Order 9863. And to be clear, Delmarva is not asking that the Commission reconsider the EDIT directive that was contained in paragraph 1 of Order 9863. Order 9863, as you will recall, was the product of staff's motion to re-argue a previous order, Order 9853. Order 9853 severed the EDIT issue in Delmarva's electric rate case, among other things. But importantly, those other things did not include either a reprimand or a remediation plan. With this motion, the Commission's task that Delmarva is asking is that it reconsider if those reprimands or remediation plans were properly issued, properly authorized. The more specific question is whether the Commission's regulations authorized staff to include a new issue, the reprimand and the remediation plan, for the first time in a motion to re-argue. The second question is whether it was correct to issue a reprimand in the absence of any evidence of intentional misconduct. And the answer to both of those questions is no. Now, before I get into the reasons about why the Commission should grant Delmarva's petition, I first want to take a moment and to acknowledge to Mr. Walsh and to Mr. Geddes and to the Commissioners the concerns that staff has raised in this matter. That Delmarva hears those concerns. We recognize those concerns. And later in my presentation, I'll discuss the ways that we're working to fix those mistakes. But before doing that, I do want to get into the reasons why the reprimand specifically should not have been issued. And just to be clear, any mistakes that were made does not affect or change the reasons why the reprimand should not have been issued. From a procedural perspective, when we look at the motion that was made to re-argue, it was made under Regulation 1001.2.22.2. It's the one on a petition for rehearing and reconsideration. And I want to cite for you some of the specific language in there, because it says you've got to set forth in numbered paragraphs the grounds for rehearing and reconsideration that are different from the arguments previously made to the Commission. What that means is that when you have a motion to re-argue, a motion to reconsider, or a motion to rehear, it implies that the matter has been argued once before, heard once before, there's been an order on the issue before. That's why it's to rehear it. The problem with Order 9863 and the reprimand that's in there is that there was no underlying order on a reprimand to re-argue. When you go back and you look at what's in Order 9853, you're not going to find anything about a reprimand. You're not going to find any language about a remediation plan. It wasn't raised until, for the first time, on staff's August motion to re-argue. Because of that, filing that under this regulation, the 2.22.2, was not authorized. It could not have been brought.
Mr. Jordan,
Yes.
I apologize for the interruption, but we've had a little technical difficulty and we need to fix it. It'll just be a moment, so
Sure.
my apologies.
Welcome to the conference center. Please enter your moderator code or your participant code, followed.
Your passcode has been confirmed. Please wait while you are joined to the conference.
Please proceed, Mr. Jordan.
Thank you, Mr. Chair. What I was mentioning in this procedural argument, and the question for the commission to decide this issue really says, is there an underlying order on a reprimand or a remediation plan? And if the answer is no, which it is, then bringing that issue for the first time on a motion to re-argue was not authorized, and the commission should grant Delmarva the relief it seeks, just on those grounds. Those are the procedural reasons. The second issue that we have here gets really down to the conduct at issue. And the question here, as Delmarva puts it, is for the commission to decide whether, when it issues a reprimand, if it requires some sort of intentional misconduct or not, or if a violation itself is all that's needed. There is no case law, legal authority, statute, regulation, or anything else like that directly on point for the commission's help in this. What we have and what Delmarva has included in its petition are the way every single Delaware trial court handles this kind of a topic. They've all got rules of civil procedure, and this is Rule 11 that's included in the petition. And what we included in there was also an example from Superior Court about the sort of intentional misconduct that is required to trigger a reprimand or any other type of sanctions. It's not for something where there is a mistake. It's not for something where there's a legal disagreement over the meaning of terms or how they're applied. It requires intentional misconduct. The intentional misconduct example that I provided involved an attorney who lied to the court about what documents he was replying to in a way to try to avoid a judgment against his client. And when he was caught out on it, he lied again. That's very clearly intentional misconduct. That very clearly triggers and justifies a reprimand or any other type of sanction. We don't have that in this case. This issue has been in front of the commission several times by now. The commissioners heard the facts back in August when this was first argued. But what the point stands here is that at that hearing, that we saw in the transcripts too, there's no nefarious intent from the parties, specifically Delmarva, with regards to this. When Delmarva was told to file a separate motion to modify the settlement agreement on the EDIT issue, it did. It's going to be heard later this month by the commission. There was not that level of intentional misconduct that's needed to issue a reprimand. Now, in the response, in staff's response, it argues that the commission and staff does not need to show any sort of intent. The violation is in and of itself sufficient to justify a reprimand. staff does not cite any legal arguments, or legal citations, I should say, in support. But if it comes down to a policy question about what the commission should do in that absence, I think what you've got to look at then are the consequences that flow from saying just any violation, any technical violation, without a regard for intent, justifies sanctions or a reprimand in this case. The difficulty with accepting that position is that sanctions are very serious business, of course. And in order to get there, you need to have some level of behavior that's equal to that seriousness. That wasn't shown in this case. What it threatens to do by saying any violation, the company steps out of bounds while it's running the ball down the field, is a violation. The risk that creates is turning what are otherwise mundane legal disagreements into something that could be sanctionable. For example, in this case, the electric rate case, and in the gas rate case, staff filed motions to compel. Ultimately, the hearing examiner disagreed, but the concern is, had the hearing examiner ruled otherwise, that Delmarva did not produce the discovery under the regulations, would that require some sort of a reprimand or sanctions? And Delmarva's answer is no. There needs to be some sort of finding of intentional misconduct. And that's the second reason why Delmarva believes that the commission should go back, reconsider this reprimand that's included in Order 9863. At the very beginning, I did mention the seriousness of sanctions, the seriousness of this reprimand, and how seriously Delmarva takes, staff's concerns. They're not on deaf ears at all. Without violating any issues with my client, we did come up with a process to look at this to reduce the chance that this happens again, this sort of EDIT issue happens again, or that action is taken without first coming to the commission about a settlement agreement. Now, this specific issue, this EDIT issue itself, is a novel, complicated, and complex issue. As I understand it, Delmarva is the public utility in Delaware that has been the torchbearer on this issue and has worked to return this money to its customers quickly. However, as I mentioned, the concerns that staff raises have been taken to heart. There has been a process put in place so that, again, to try to reduce the risk that this happens again. Part of that includes taking closer looks from the legal department, myself included, at previous settlement agreements, of course. Delmarva's also looked at, when it takes this sort of action, is first coming to the other parties, of course, getting their position on this, to avoid this from happening again. And then when it comes to filing a rate case in the future, the company's come up with a checklist against the minimum filing requirements that are there to be certain that the contents of the rate case comply with those minimum filing requirements. The message that I want to leave the commission with before answering any questions that you may have is that the company takes its reputation very seriously. When it shows up in June to deliver a state of the company, it is very proud of the various high marks that it gets for customer satisfaction, and it enjoys letting the commission know about that. We also understand, as I said, staff has legitimate concerns. But what this doesn't get to is that level of intentional misconduct, that intentional wrongdoing that justifies a reprimand on the company. And so, Your Honors, I would ask that the commission grant Delmarva's petition, and I'm happy to answer any questions that you may have.
Thank you, Mr. Jordan. Ms. Iorio, are you part of this?
I am not. I'm sure you're delighted to hear that.
Ms. Iori, we always, always, always appreciate your input. It's always good. But no more talking today since you're not providing input. Mr. Walsh?
Does that mean during the hearing, too?
Thank you, Mr. Chairman and Commissioners. Tom Walsh, Staff Counsel. Before I get into the specific arguments, the key here for Delmarva's petition lies in whether the concerns expressed by Commissioner Gray at the last hearing on September 15th and the resulting order are now retroactively gone. Everything that happened to create those concerns, and those concerns, this should not be lost, that the, and I'm quoting from the transcript, page 2194, lines 9 through 17. In the discussions and presentations that I've seen, that the bills didn't change, don't appear to change when the refund amounts did. And in large measure, some of the comments that were made about proposals versus implementations had already taken place. Those are facts. That has already happened. Proposals, and I accept Mr. Jordan's presentation as to Delmarva's taking this very seriously. But what was proposed back then and the arguments as to discovery and all those things, they're outliers. The facts are what was implemented, and we know what was implemented. And that is what created the Commission's concern. And those weren't done by accident. Staff does not have to show some sort of intentional conduct by preponderance of the evidence or clear and convincing evidence or beyond a reasonable doubt or anything like that. This is the Commission's discretion to weigh the evidence, the record, and when that concern is found and the reprimand is put in place, that is an evening out of things. Sanctions sounds a bit melodramatic. This isn't sanctions where the Commission has enforced penalties. Certain experts or counts are no longer permitted to do certain things. It's just a one paragraph, 2 or 3 lines maybe, in that order that serves as an incentive to do exactly what Delmarva appears to say they will be doing, and I believe they will. But maybe they're doing that because of that reprimand. Now, let me backtrack to the procedures issue, because there were 4 basic arguments in the petition that this was procedurally improper. There is no clear requirement that there be an actual written order entered. There's no Public Service Commission precedent for that. If that were the case, then if the Commission were to, hypothetically, Commission does not issue an order, would a party have to wait a week, if that were the case, for an actual order to come out? In lieu, and in the interim, not mitigate something that is occurring. There was a decision and findings, and while they may not have been in order, staff had a duty to address that as quickly as possible. And the Commission allows us. In fact, the Commission itself has done this. I know because I've been part of it. Ronette, if you would show the slide 1. I just want to make, and this is back to one of our favorite topics, or dockets, I should say.
Your Honors, if I may, while we're waiting for that, we did not see any of these slides ahead of time. They had not been shared with us, although there was a request yesterday that if any slides were going to be displayed, that they be shared with us first. So I have not seen these, and Delmarva would make an objection for the record.
And Chairman Winslow and Commissioners, in terms of timing, I got my request for this to be first chair on this hearing at about 10 o'clock this morning. So I just received these early this morning, and they're not being entered, offered for evidence. This is just for the sake of highlighting an example from a past docket. Ronette, if you could blow that up.
Objections overruled.
Ronette, are you able to? No, we can't blow it up. Okay.
Why don't you tell us what it says, Mr.
Well,
Walsh? It's a prior, is this,
it's from the March 18th, 2018 Reg 56 hearing, one of our favorites, wherein the commission was going to, right on that second page there, was going to rule on Order 9197. I know because I drafted that order with a lot of input from the various parties, and we were ready to present that order. And Mr. Chairman, you had made, asked your counsel, who was then Mr. Willard, if the commission found that the parties' arguments were not, and I wish I could read exactly what it says there. The commission had made a ruling on 3 issues within Reg 56, and that ruling was made in December of 2017. And in March, when we presented this order, Your Honor explained to Mr. Willard that the commission's rulings as vis-a-vis the parties' arguments did not still stand, and asked that the parties come back and re-argue Reg 56 so that the commission could reconsider. And in fact, we did, and everybody agreed to it. And there was no order in place to reconsider or re-argue. So just by virtue of the discretion the commission has to utilize its rules of procedure to further the Public Utilities Act, that alone is all the reason we need to hear as to why this is procedurally proper. There's no prohibition against what staff did. So, and the staff filed that motion with proper notice, and Delmarva filed a response, and there was oral argument. That sounds to me as if it was as procedurally proper as we could get under these rules. The next argument Mr. Jordan presented, he focused heavily on the intentional misconduct. Now, again, there's no requirement for, in any case law concerning this commission, any appellate case law concerning this commission, that there's a requirement of wrongdoing. That being said, what we do know is that Delmarva, as a PSC-regulated utility company, violated the minimum filing requirements. That happened. And the customers were misled. That happened. That was the basis of Commissioner Gray's concern, as previously cited. So there is no legal requirement for staff or this commission to show intent, wrongful or otherwise, on the part of Delmarva. The regulations were violated. They did not explain in any sufficient detail why they were violated. It would stand that they were, the violation was not an accident. So this commission, with its plenary authority to enforce its own rules and regulations, is able to issue an order of reprimand and order as well a remediation plan, because that's part of its exclusive original supervision and regulation over public utilities. That's how this commission furthers all the policies under the Public Utilities Act. Now, if we were to be held to some sort of intentional standard, I would ask the commission to consider, Ronette, if you put up the next page on the slides, next one after that. Okay, so these are the minimum filing requirements. And what you're not able to see there, I'm not sure why we're not able to get, I will just explain, and this is all on the record, and it's in the details of staff's motion for re-argument. On the second page of the index to schedules, in the left-hand column, under filing requirements designation, is 2.1.5. And the description is items departing from prior decision. And it says Schedule C. And on the next page, you'll see the heading Accounting Elements Departing from Prior Decisions. And on the next page, thank you, Ronette, the circle below there is where this EDIT amortization should have been dealt with. This was required. It was not done. If it was an accident, it hasn't been explained. I would submit to you that it was omitted. If we want to call that deliberate, I think that would be a fair characterization. On the next page, if you would, please, is where we have inserted modification of EDIT settlement balances. That is what is missing there. So the commission can consider whether that was intentional conduct. If it were not intentional, then I would submit that as a sophisticated PSC regulated utility company, it was careless enough to warrant the reprimand to ensure that it doesn't happen in the future. I think that is commensurate with the error, particularly when that error resulted in $1 million that was not flowed back as it should have been. So this idea of a mistake, as it was characterized, it could have been a mistake. Maybe it was a mistake to make that decision to omit it. I don't know, but it happened, and that is a record. And there are consequences that flow. Mr. Jordan mentioned that there are consequences that flow from having a reprimand. Well, there are consequences that flow from violating the minimum filing requirements. They are, in layperson's terms, the least of what must be done. That's why they're minimal filing requirements. And that was not met, and should have been. Again, the idea of sanctions should not equate that term with a reprimand. This is not a reported opinion where somebody is being disbarred, and the cases that Mr. Jordan referenced. There are also cases that state that for mere negligence, reprimand is enough. Where there's intentional conduct, sanctions come into play. Well, I would argue that this was intentional conduct, yet we only have a reprimand. So maybe we're erring on the softer side of the ordering paragraph language. As far as there was an argument by Delmarva had made about the sanctions ordinarily being the subject of a separate motion. Again, there is no commission rule that specifies that. As I stated before, the commission was given the statutory authority from General Assembly to enact rules and promulgate regulations that ensured that it could fulfill compliance with the Public Utilities Act. And that is what was done. Whether it was in a separate motion, I think is really just irrelevant to the whole decision. So, as we stated in our response, there is no new fact that Delmarva sets forth that would give this commission reason to change its decision from September 15th based on things we all know happened. If the commission can go back in time, explain today why it can go back in time and no longer be concerned that there was a difference between the proposals and the implementation, and that Delmarva did in fact include those EDIT balances as it should have in its schedules, and that there were no motions to compel required. All those things. If that can happen by virtue of looking back in time and having a different decision based on something that truly has changed, that would be one thing. But that's simply not there. It's a reprimand to ensure future compliance. The refund plan ensures future compliance. Delmarva says that it wants to ensure future compliance. I think we have a trifecta here, and they should all stand. Staff has presented a proposed form of order, 9893, which was attached to its response and denies Delmarva's petition, and respectfully, I would request that the commission enter that order, let the reprimand stand. It was proper, it was just, it was supported, and it was considered by this commission, and now we have no new facts that would warrant reversing that consideration. Thank you.
Thank you, Mr. Walsh. Excuse me. Commissioners, do you have any questions? Well, I guess, Mr. Jordan, do you want a couple of minutes?
Yes, Mr. Chair, if I could, just a couple of minutes. I will be both brief and concise with my time here. And I want to start with Mr. Walsh's comments about that this is a reprimand. It's only a couple of sentences long. and it's only in an order, it hasn't been publicized, that sort of thing, Delmarva takes that seriously. It's the quality of the thing, wherever it is. The documents and the arguments related to the documents that were displayed for the commission could have been made, and probably should have been made, in staff's response, but they weren't. They weren't in there. And so they shouldn't be considered now. Bringing them up during the hearing does not provide, with any litigant, Delmarva or any other utility, with a fair playing field or notice of the arguments that are going to be made. But what's more important than that is what was shown. There was nothing connecting that to this case. When Mr. Walsh talked about Regulation 56, now I was not here for that, but what I heard him say was that at some point the commission asked to rehear things, but that's not this case. In this case, we have a litigant invoking the commission's regulations, staff, back in August, to petition for reconsideration of this EDIT motion. That's the rule. The benefit of that rule is that common understanding of rehear, reconsideration, or re-argue means it's been heard once, it's been argued once, or it's been considered once. And if that doesn't exist, if there's no underlying order upon which to predicate that argument, it's not authorized. That's the way it goes. The fact is, this case has been litigated. It was the subject of 4 or 5 days of examination and cross-examination and examination and cross-examination back in February. There are exceptions filed. There are arguments made to your honors about this case. That could have come up, but it didn't. What this comes down to is not about, frankly, the commission's jurisdiction or its ability to enter sanctions. That's not controversial, it's not disputed, it's not the issue. The issue is how it uses that power. And the example that comes to my mind is one that anyone with kids or grandkids would be familiar with. It's the difference between a kid who accidentally knocks over the cup at the dinner table versus the kid who throws a cup of water at his brother because he made a smart comment to him. The kid who throws the water should be in trouble. The kid who accidentally knocks it over should not be reprimanded, should not be put in timeout. It was a mistake. That's what we have here. That's what's going on here. And so with that, Delmarva also included a form of order in its petition. And so we would ask that the commission enter its Delmarva's order, grant its petition, and remove the reprimand that is in Order 9863. And I'm happy to answer any questions, Mr. Chair, that you or the commissioners have.
Thank you, Mr. Jordan.
You're welcome.
Any more? Commissioners, you have any questions? Commissioner Gray.
Thank you, Mr. Chair. This is a very difficult decision, I would say, at least in this seat on the commission. I think Mr. Walsh resonated one thought with me, is that no new facts, based on my perspective, have been revealed on the table. But I do have a couple of curious questions. Do we know who first learned about the EDIT matter being implemented and how? Do we know who first learned about the EDIT matter? Mr. Walsh, do you, from the testimony that has been provided in this case, know who first learned about the EDIT matter?
Commissioner Gray, I would could only venture an educated guess, I would like to call it, but it was sometime after, I believe, when we were putting the minute order together, that things were revealed that made us want to change that minute order. We know as late as the 18th, based on a response that Delmarva filed to staff's motion for your argument, that they were still maintaining that from the customer's perspective, nothing changed as it related to the EDIT credit. So we were still being fed that information, so it was sometime after that.
Okay.
Your Honor.
Please.
I may have some information that will
Jordan.
help with this too, because it was my understanding that the company's witnesses and that staff's consultant, that this topic had come up back in August of 2020, when I think it was Mr. Zeminski had emailed Mr. Paff about this EDIT issue. And that's when I was under the impression that this first had come up, that it had first been raised, that there was, that this issue was there. And as for, I don't know if Your Honor was directing a question to me about new facts or no new facts. The point I would make, the answer I would give Your Honor about that is that it was August 25th, at that hearing, likewise, there were no facts then about this intentional misconduct that Delmarva says is needed to justify or to trigger this reprimand.
So, Mr. Jordan, let me ask you, since you suggest that it was revealed in 2020, was it revealed and recognized by the company as a mistake?
I don't think it was understood as a mistake at that time. What I'm getting at, Your Honor, is I don't want to go too far into an area that, unless I can give Your Honor the exact language here. But what I'm saying is there was an issue about how this EDIT would be handled. It was, as I understand, the first time that this EDIT issue had come up. And so, you know, the company was treating this the way it treats its per books. The difference here being that there was a previous settlement agreement that was involved that the company did not, I guess, realize and put that in. And so the point I'm making is that this had been raised at least as a potential issue back then.
Ms.
Okay.
Ivory, excuse me, Commissioner
Yep.
Gray. Ms. Ivory?
Here.
I know, I'm sorry, I'm having a little. The issue did come up during the case, and the issue came up because staff's witness, to his credit, found it buried in over 1,000 pages of testimony, exhibits, and work papers in one line. And then he tried to get discovery about it, and Delmarva fought tooth and nail about it. So they did not admit at that time that this was a, quote, mistake.
Thank you, Ms.
Thank,
Ivory.
Mr. Chair, may I continue? Thank you. Why was the EDIT refund adjusted and implemented while informing the commission that adjusted refunds would be proposed?
I have a hard time hearing it, Your Honor, I'm sorry.
All right. So why was the EDIT refund adjusted and implemented while informing the commission that adjusted refunds would be proposed?
Your answer, my understanding of this is, and my answer is very similar to the one I just had provided, that this had been treated the same way that Delmarva would treat its per books, that this was getting the same treatment as those, and that it was not, that this was not going to be handled any differently.
But wasn't there an order with respect to the EDIT refunds under which the company should have been operating?
If Your Honor is referring to the settlement agreement that was entered as the order, is that?
That's sufficient?
Yeah, that's where the mistake comes down to, Your Honor, is that settlement agreement, and let me go back to Order 9853 and 9863 rather, because that's what's in there. It's about a deviation from the settlement agreement, not these minimum filing requirements. And that's where the problem comes, is because the company went away from, or deviated from, the settlement agreement. In response to that, the commission had asked that the company file an EDIT motion to, I suppose, modify the settlement agreement, and it would take effect nunc pro tunc. And so we've got that one coming up.
Sorry, Mr. Jordan, if the company deviated from the settlement agreement and this was something you recognized in 2020, why wasn't the information revealed to the commission?
Well, the idea that it had deviated from the settlement agreement, the way Your Honor had phrased it, I don't think that's what we're saying about August 2020. I think that issue did not come up until a little bit later, when Delmarva realized that, okay, there was this settlement agreement that should have been modified beforehand, and that didn't happen.
Okay, so.
Let me see if I can
Mr. Chair.
help out if I could.
Yes, I'll yield. I have 2 questions when you're done.
Okay, let me see if I can help out. And I'm not sure that I can. There was an order, and it implemented the settlement between the parties. And it said that Delmarva Power and Light was going to give back X number of dollars to its customers on their monthly bills over a period of time. I don't remember the equation. That was on the bill and being given to everybody who was a consumer, and that never changed.
Correct.
That never changed. The customers, I guess until the last order we did, until they changed it in September or early October, that never changed. But what happened was the company implemented its interim rates. And in those interim rates, it made an adjustment for the change, or I forget the language the company used, the proposed new rate. And that, in essence, took away from another route the money was given to the consumers under the rider in the agreement. So the company is now responding to staff and saying, well, we didn't change anything to the consumers. They're still getting their EDIT special rider, get your money back. and they either forgot to mention, or didn't dawn on them to mention, or they made a mistake, or they intentionally just didn't talk about the fact that they had put into the interim rates what they wanted, which was the EDIT changed. So, you know, the company is answering questions from staff at DPA, saying, no, we didn't change the rate, we didn't change the settlement agreement, but in fact, practically speaking, I mean, judging from the amount of money that was going into a consumer's pocketbook, they did in fact change it because of the interim rates. Then on top of that, the interim rates are something that's authorized by statute. So that whatever way this comes out, the consumers are going to be made whole, plus with interest if we rule in favor of staff. So this whole situation is troublesome because the minimum filing requirements have a purpose, and it's stated right in them. And of course, the company failed to abide by the minimum filing requirements. And of course, it's problematic because when you look at the minimum filing requirements and what everyone's supposed to do, it doesn't anticipate this situation. And so we're left, as everyone's pointed out, with all these issues that we now have to decide or try to resolve today. Commissioner Gray.
Thank you, Mr. Chair. That's a very good characterization. So what I'm left with in consideration of this matter is, how can the commission, trust the testimony filings conformance with commission orders? That for me is the main concern. And on the other hand, any punitive decision-making we make here ultimately finds its way back to the ratepayers. So we're sitting on this fence trying to make a determination, what is the right outcome here? So if, what can we expect as a commission in the future in such a way as not to be in this predicament again? What is the solution option from the company's perspective? If you were doing this all over again, what would you do different?
So, Commissioner Gray, one of the items that the company has implemented to catch this sort of thing again is to go through and checklist what's in a rate filing against those minimum filing requirements, and to make sure that we've got 2 columns of boxes, that both columns are being checked off. That this sort of a thing, and if we're going to speak about EDIT specifically, that it's going to be included. I mean, I don't mean to sound short, but when I say it's going to be included, it's going to be included. There is a check system now in place that, to my knowledge, didn't catch this before, didn't exist before, that is in place now. So when there is the next rate filing, there will be a way to compare and similar to, I suppose, the Excel spreadsheet that was up earlier, show where here's the minimum filing requirement and here's where it is. When we're going to prepare a rate case, there will be assignments for individual employees to check for that. Each person will have an assignment. And one of the ones that will be there will be to make sure that those minimum filing requirements are met. I said this earlier too, Commissioner Gray, about how this EDIT issue specifically is a complicated and complex thing. Within that complexity, there was enough room for the company to miss it. And that's what happened. Ultimately, Mr. Chair was correct that in the end, the customers are getting what they're entitled to. Absolutely. And as for how can the commission accept or trust the testimony coming forward, I think that was the other question that Your Honor had. The point is, the difficulty that we get into here, because there was no nefarious intent. So, for example, if there had been someone who had forged a document or had gone through and changed.
Mr. Jordan, I want to interrupt you. I mean, we've heard that argument. We understand what you're arguing. I guess actually Mr. Walsh might even agree with you because he used the word commensurate. You know, the punishment should be commensurate with the crime, so to speak. So let's move on to something that's new.
Fair enough, Your Honor. I mentioned there is a remediation plan. I mean, I believe, and I'm certainly happy to get back to Your Honor in writing on this, that that remediation plan will be shared with staff about how the company intends to go forward and correct these issues and to catch these issues. And I'm happy to follow up with Your Honor about that in writing, if you'd like.
Commissioner Gray, just 1 second, please. Ms. Iori.
Thank you, Chairman Winslow. With all due respect to my colleague, the road to hell is paved with good intentions. All it would have taken for this was for somebody at Delmarva to review the settlement agreement from the most recent case. That didn't happen. what I have heard is that, well, we have a checklist and we're gonna make sure that everything that's required by the minimum filing requirements is in there. Well, guess what? That is probably what they did this time too. It goes deeper than that. I mean, this is, I
Just
guess I'm
let me
here-
know the factual background from this deeper
Yeah,
conversation.
So how do you make sure this doesn't happen again? I'm not sure that anybody can guarantee that. Honestly, I'm not sure that anybody can. But the fact of the matter is, what the commission did was, having heard all of the argument from the parties, decided that it was appropriate to reprimand Delmarva and require a remediation. And that is what you are considering here, whether you believe that order is still proper in light of Delmarva's motion for reconsideration.
I'm sorry, Commissioner Gray, I promise I won't interrupt you again.
No, go ahead, Mr. Chair.
No, please, go ahead. Oh, have you finished?
I'll just make a supplemental comment with respect to Ms. Iori's statement. I agree that a checklist is not going to solve or be the salvation to prevent this from happening again in the future, especially if one looks at some of the elements involved in this case, such as testimony provided that we're going to propose something that we've already implemented. A checklist isn't going to prevent that from happening. And that's the type of issue that concerns me, because now we're given perhaps untruthful information upon which we're trying to make informed decisions. So that's the type of fix that I'm kind of searching for out of the decision in this case. So I'm not convinced the checklist is going to give you everything that you're looking for in that regard. So, Mr. Chair, I'll yield back.
Well, this matter is very, very complicated, much more complicated. Every time I look at it, I go, wow, I didn't realize that. And I think I'm still sort of in that situation. I mean, I understood, that there was a rider. I understood the effect of the interim rates. And I'm not sure why. I mean, the interim rates and what they're composed of is pretty standard. I mean, so, and I don't really see any, we talk about intentionality or some other omission or whatever, but there's really very little factual background in the record with respect to exactly how we find ourselves at this point in time in terms of culpability or trying to judge what's commensurate or not commensurate. I mean, obviously, they failed to comply with the minimum filing requirements. Obviously, that in and of itself is a serious matter. But you know what happens, mistakes do happen, and they're going to continue to happen, and nothing we do, checklists or training or education, is going to completely eliminate mistakes. And another avenue we don't have before us today is that there's an issue still out there that relates to this particular situation. I mean, how does that impact, or how does this decision impact that, and vice versa? Is this really a timely time for us to decide this issue or what we should do? And also, the minimum filing requirements section anticipates that you'll find this issue out earlier, and you'll address it, hopefully, at the hearing examiner level. And the hearing examiner will do some work and find out what the facts are and how serious or not serious the infraction was, and then make the party who's not complying, which would probably be the company, comply. So it doesn't come before the commission. So this is unusual that the commission is in this situation, having this sort of a discussion. Staff, at some point in time in this whole rate case, made the suggestion, and I think it was to the hearing examiner, that, gosh, this can't happen again. This is, we can't have this problem. We should be looking at our rules and regulations surrounding the hearing examiners and discovery and making sure the company provides what it's supposed to provide. In other words, strengthening the discovery process. And I don't remember exactly where that is, except I don't believe it got much traction with the commissioners when we heard about it. Obviously it didn't get much traction with the hearing examiner. So that's something that's on my mind, was staff's request really a pretty good request? We should have maybe recognized that and done something about that, or that would help in the future. I don't know, there's, when you have to sit here and make decisions like this, it's not easy. And then not always do you really realize the full extent of the impact of what your decision is going to be. So I've said it before, and I'm going to say it again, and I keep asking for facts and what, what happened and, what's the degree of culpability. And I always hear from the company that, there was a misunderstanding, that they didn't do anything intentional, that they didn't intentionally omit information. It doesn't look good. And I'm very happy to see the attitude of the company today as we discuss what to do. And I don't know. Usually I'm pretty good about trying to make decisions, but I don't know. This is tough because it's, you say, well, they did something wrong, so let's reprimand them. Okay, so we reprimand the company, and that reprimand may have repercussions that go outside of this office or this thing, and really not intended by anybody around these tables. I mean, we're not an island. People read our orders. They recognize when we use words, and those words have impacts and ripples outward. Of course, the company should know that very well, and they should have abided by the minimum requirements. So, Commissioner Gray?
Mr. Chair, this may be an unusual request. I would appreciate 5 minutes of consultation with our legal support in this matter. I'd like to propose an executive session, move that we go into executive session.
Mr. O'Brien, we'll just wait till we have a second.
I second.
Mr. O'Brien?
Chair Winslow, Bill O'Brien, Commission Counsel. I've actually recently done some research on the propriety of going into an executive session to get legal counsel on the matter at hand. We're actually set up for you to get legal counsel out in the public. The legal counsel that is appropriate for executive session is when the commission is involved with litigation outside of the matter before the commission, something like at FERC, or an appeal of the commission decision to Superior Court, those types of things. But a matter before the commission, legal counsel is appropriately given in the public.
Fair enough, Mr. Chair. I'd like to withdraw my motion.
Yes, sir. That's so ordered, or so done, or so completed. Mr. O'Brien?
Yeah.
Do you think that the commission's reprimand order is adequately supported under the law?
Well, Chair Winslow.
Only based upon everything we've heard today.
Right, and when Commission Counsel looks at orders to see if they're adequately supported, of course, they're asking themselves, what if this went up on appeal? I mean, what would an appellate court look at? And of course, there needs to be adequate support in the order and in the record to support that. So Delmarva has made two different arguments here regarding the order itself, one of which is procedural. And frankly, I agree with staff that there's not a procedural flaw here that would doom this order on appeal. Certainly, a public reprimand is a very serious issue, and procedurally, perhaps it would have been cleaner in a separate motion. But Delmarva did have notice that staff was seeking a reprimand. They had an opportunity to be heard. They didn't ask that that part of the order be pushed to another proceeding or another date. So I would not go so far to say that procedurally this thing would come back at you. On the other hand, if you look at the support for the reprimand substantively in the order, I do think that there is a lack of support from a legal perspective. You know, we've heard about the MFRs today, but the order itself does not cite to the MFRs at all. Even if it did cite to the MFRs and use that as a reason for the reprimand, you know, the MFRs have the remedies for violations of the MFRs baked into the MFRs. So, you know, what happens when a company does not comply with the MFRs is that, and once they're alerted to a deficiency, if they still don't comply within 15 days, then staff can move the commission to reject the application. Well, of course, that didn't happen here. And I'm not saying that's the only way to address this, but for a commission to rely solely on a MFR violation to issue a public remand when it didn't go through the steps that it had set up for itself for violations of MFRs, that might be an issue. What the order did say was that the company improperly modified a settlement agreement. Now, I think today we actually got some clarification around that issue, and it came down to Commissioner Gray's questions around how did the company implement their requested change in the EDIT balances? How and when was that actually implemented? Presumably in violation of the settlement agreement. Well, what we heard today, and we all seem to realize now, is that the implementation of the request was done only through interim rates. There was no change in what came out of the settlement agreement itself, which is a permanent rate. When I say permanent, I mean there's no giving back the money on that EDIT rider. The benefit from that rider that the customers saw can't be taken back. So that's always there with the customers. So the question is, did the company violate that settlement agreement by including its requested treatment of the tax benefits in its interim rates? Well, what we've seen and heard today, even from Chair Winslow, is that the statute permits a company to put its entire request into interim rates. There's no look at what the merits are on the underlying items in that request. Does that sound unfair on its face? Well, it's in the statute, and it's because these things are usually put into effect under bond in order to protect the customer, so that those monies, those revenues will be returned to the customer if the company ultimately loses the issue that led to that revenue. So is that a violation of the settlement agreement to put something into effect through an interim rate that's permitted by statute and which is subject to refund with issue if the company loses the case? It's hard to support a finding in the order that the settlement agreement was violated based on an interim rate that's allowed by statute. So, two things. There was not analysis around that finding in the order. You say, well, what if we take it back and just beef it up a little bit, Commission Counsel? You can do that for us. Well, I could certainly attempt to do that, but what I'm saying right now is that I don't even find the support in the record to show that they violated the settlement agreement. Certainly, they violated the MFRs, but again, the order doesn't cite the MFRs, and we have other remedies around violations of MFRs. You know, from a legal perspective, you know, everybody seems to agree that, you know, the seriousness of a remedy or a directive from the commission should be roughly balanced with the amount of process or support for that finding. Right, so I don't think there's any question that a reprimand, a public reprimand, is very serious. So The order itself does not point to an intentional violation. Maybe the commission would ultimately find that. I'm not saying it's strictly required from a legal sense, but it is a very serious thing to publicly reprimand a company. And if you do it based on a mistake, then, we should say we're doing it based on that mistake, and that there was a reckless disregard for the MFRs or for the prior settlement agreement, or however you want to frame it. But it does seem like there should be more analysis around why this infraction rises to the level of a public reprimand. So that's just my independent legal opinion on whether that order itself is adequately supported from a legal perspective.
Chairman Winslow, may I ask one question?
Of whom?
I think it actually refers to something that council said, and I want to make sure that, because we do have, or you will be considering, a motion to amend the settlement agreement that Delmarva has filed, and responses to that motion from the other signatories to that settlement agreement. And I can assure you that at least the DPA's position on it is that the settlement agreement, that they did not have, that it should not be amended. And I think what I heard Mr. O'Brien say, is that he didn't see a basis for a violation of the settlement agreement. And I'm not sure whether he was just referring to it in terms of the implementation of interim rates or a broader issue, and that's what I want to clarify.
Yes, we go Mr. O'Brien to clarify.
Yes.
Certainly, if I may respond. Right. I am not making any statement regarding how the EDIT balances should be recovered based on the motion that's coming in. My only statement is whether the settlement agreement has been violated already because of the implementation of an interim rate.
Just a clarifying question, because interim rates, if they're wrong, are refundable. Is that correct?
Well, it's correct, and because interim rates by statute are allowed to be put into effect based on the full request by the company.
Commissioner Gray?
So, Mr. O'Brien, what I hear you saying is that, number one, and we based, I think, I based a lot of my decision last time on remarks that Mr. Geddes made about those interim rates, and the fact that the proposed rates were already implemented. And so you're saying that that did not violate any agreement, and the prior settlement agreement, because those rates are interim rates and they're allowed. Is that correct?
That's correct.
And so then there was no intentional conduct because those rates could be corrected in this final settlement agreement. Is that right?
Well, just to parse your words, Commissioner Drexler, in my opinion, there was not an intentional violation of a settlement agreement by putting into effect interim rates that are allowed by statute and that are subject to refund with interest.
Right.
I'm not speaking to whether they violated the MFRs intentionally or not.
Well, it's the rate. It's not the MFRs. It's the
Right.
rates, and that, and Mr. Jordan, I think you were pretty clear that, and you admitted or agreed a mistake was made, but this was not intentional conduct by a person or persons.
Correct.
Thank you.
May I make one comment?
Did you say one comment?
One comment. I've heard mistake used to describe this. What I heard Mr. Jordan say and what those MFRs showed was, as he described, a deviation. Wasn't a mistake. It was a deviation. Those are the facts.
And with all due respect, Commissioners and Chair Winslow, when we file our response to Delmarva's motion to amend. We are taking issue with Delmarva's claim that this was a mistake.
Commissioner Gray?
I think I started out by saying this is a very uncomfortable decision to make, and there are a number of reasons why. Sometimes before this commission, and this goes to our council, sometimes before this commission, we're brought what's called a settlement agreement from all the parties. And what I'm worried about, in the one hand, is I don't want to be in this position in the future again. I know the company has committed to take certain steps to avoid that happens. But if it happens repeatedly, that also would be an issue. Is there any merit, is there any value to remove this matter into some form of settlement by all parties that brings a solution to the table palatable to all? Mr. O'Brien, is that an inappropriate question for legal counsel?
Well, we all prefer settlements, Commissioner Gray. Sometimes a judge will say to the parties, go out and settle this. You do have a petition before you right now that requires a vote. So, as your legal counsel, I would suggest that you take that, take that vote, unless the parties right now want to commit to trying to settle the whole thing, including the reprimand. I mean, the only thing right now before the commission is the reprimand and the remediation report. The company did not challenge the change to its interim rates that was part of that same order. So whether it's appropriate for the commission to say, go settle the reprimand order, I would not advise you to do that unless the parties all asked you to do that.
I'm listening.
Commissioner Gray.
I yield,
You
Mr.
know,
Chair.
I voted, well, everyone knows how I voted. So you two guys, I mean, if one of you two guys decide that you're not going to vote for the motion, obviously the motion doesn't pass. Needs all three of us to pass. So the only thing I'll suggest, and I don't know if this has any legs or not, but I would just suggest to you that we make a finding that the MFRs were not complied with. That we, because of the lack of scrutiny due to time, have the facts to determine the degree of culpability involved, that we issue a warning to the company advising them that a subsequent violation of the MFRs will involve sanctions, reprimands and sanctions, and also could adversely affect any pending rate matter or rate case associated with the MFRs.
I'd like to make a motion to adopt proposed order 9893, granting Delmarva's petition.
Point of clarification, Commissioner Drexler, I understand that's on the table, but.
It's not on the table yet, it hasn't been seconded.
Right, I'm a little confused because the two comments, I wasn't sure, Chair Winslow, whether you were proposing a motion to be adopted.
I was putting something on the table for consideration by the other commissioners, and I'm not sure if I interpret Commissioner Drexler's motion as to incorporate what I said or not, so that's
I
my
didn't know-
uncertainty.
Sorry. Mr. Chairman, I didn't know if that was going to be in the record in an order or whether that was a verbal warning.
That would be in an order,
Then the order as it stands would have to be changed.
yes.
And I would make a motion to incorporate the warning into order 9893.
Well, let's think about this. We've got Delmarva's motion, which obviously I guess we need to grant, if we're going to get rid of the reprimand portion of the state's order, but we also want to implement some warning and threat of future sanctions as part of all of the above. So, Mr. O'Brien, how do we do that?
I think it would be adequate to move, remove from the prior order the reprimand, and if you decide, the, what was the name of that report? Remediation plan. And then either with that motion or with a separate motion, move to issue a warning regarding further MFR violations. I think you could do that all in one order and in one motion. And what I would do as your commission counsel is take Delmarva's proposed order, which removes the reprimand and the remediation plan, and I would add to it a warning to Delmarva, and then I would circulate it to the parties, and we would bring it back to you October 27th.
That meets my objectives.
That meets my, I concur.
So do we have a motion? Do we have a second?
I'll second as edited.
Is there any more discussion that anybody wants to make on the motion? Okay, all those in favor of the motion signify by saying aye.
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 I abstain.
3, 1 abstention.
Question, Mr. Chair, do we also address staff's motion, or does that settle the matter by adopting the company's motion, company's order?
Go ahead.
Right, staff did provide a proposed order if you denied Delmarva's motion, but having adopted their motion with modifications, you're done.
Okay, thank you, everyone.
Thank you, Mr. Chair. Thank you, Commissioners. And, Mr. Chair, that wraps up my matters before the commission, if I may be excused.
Absolutely,
Thank
thank you
you.
for attending. May your next visit be much more pleasant. We're on the hearing schedule at this point in time, and at this point in time, I'd like to hand the gavel over to our learned hearing examiner, Glenn Kenton.
Thank you, Mr. Chair. I would like to beg the indulgence of the commission, because this is a full evidentiary hearing. We'll try to make it as brief as possible, but because it is a full evidentiary hearing, we have to move the exhibits into the record. We have to listen to the testimony, hopefully briefly. So I beg your indulgence as we go through the procedural niceties of this actually being a hearing rather than just a decision or a decision, just having you make a decision on the decision of the hearing examiner. For the record, I note the time is now 2:30 p.m. on Wednesday, October the 6th, 2021. This is the evidentiary hearing in PSC docket 210436 in the matter of the application of Veolia Environmental SA North America, Inc., Suez SA, and Suez Water Delaware, Inc., pursuant to 26 Delaware Code Section 215 pertaining to an indirect change of control of Suez Water Delaware. It was filed June 11, 2021. My name is Glenn Kenton, and I am presiding hearing officer in this docket, PSC docket 210436. On June 11, 2021, Veolia Environmental SA, Veolia North America, Inc., Veolia North America, Suez SA, we'll call that Suez, and Suez Water Delaware, SWDE, which I will collectively refer to as the joint applicants, filed with the Public Service Commission an application proposing an indirect change of control of Suez Water Delaware, Inc., a Delaware corporation. For Pursuant to 26 Delaware Code, Section 215, the joint applicants are seeking the approval of Veolia's acquisition of a majority or all of the outstanding shares of Suez in accordance with a combination agreement executed May 14, 2021, of which I will hereinafter refer to as the transaction. Consistent with 26 Delaware Code, Section 215D, the joint applicants are seeking an expedited review of the transaction, as the parties have agreed to complete the transaction on an expedited basis due to risks in consummating the transaction associated with receiving approvals in multiple worldwide jurisdictions, with differing timelines, including numerous U.S. federal and state regulatory approvals, as well as various foreign and European Commission approvals. The joint applicants maintain that the proposed transaction is in accordance with the law, for a proper purpose, is consistent with the public interest, and thus should be approved pursuant to 26 Delaware Code, Section 215D. This evidentiary hearing is being conducted today directly before the full Public Service Commission as provided in Order 9831 of this commission. Parties are seeking the commission's approval of the proposed transaction pursuant to the parties' settlement agreement, which has been provided by the commissioners and is thus approved draft Order 9894, subject, of course, to any corrections, amendments, or other comments of the commissioners. The settling parties have agreed that pursuant to the terms of the settlement agreement, substantial additional benefits to Delaware communities and Suez's customers are being provided. These additional benefits will be summarized today by the witnesses for the parties in their respective testimonies. By statute, the Office of the Public Advocate intervened in this case June 17, 2021. Notice of Veolia Environmental S.A., Veolia North America, Suez S.A., and Suez Water, Inc.'s application for the Public Service Commission was published in the News Journal and the Delaware State News on July 11, 2021. I held a publicly noticed comment session in Newcastle County's Gilliam Building, Newcastle, Delaware, on August 18, 2021. There were no members of the public present at the time, and thus no comments from the public in regard to the transaction. The notice of this evidentiary hearing was published in the News Journal on September 16, 2021. There is a court reporter here today to transcribe the comments during the evidentiary hearing. First, I would like to take appearances for the parties for the record, beginning with the joint applicants. Mr. Shell.
Thank you, Hearing Examiner Kenton, and good afternoon, Commissioners. Joseph Shell with Faegre, Drinker, Biddle, and Reef. On behalf of applicants Veolia Environment S.A. and Veolia North America, Inc., I'm joined today by my co-counsel, Adi Bakari of McNeese, Wallace, and Nurek, and Mr. Bakari is a member of the Pennsylvania Bar, was admitted by order of the Commission on June 23, 2021. Good afternoon.
Good afternoon, Hearing Examiner Kenton, Chair Winslow, and Commissioners. Pam Scott here on behalf of Suez North America and Suez Water Delaware, Inc.
Mr. Stoll introduced me, but I'll say my own good afternoon. Ade Bakare. I just want to say that Veolia is very appreciative to be here this morning before the chairman and the commissioners. We appreciate your taking the time for the hearing on this matter.
Ms. Howard.
Yeah, thank you all very much.
Good afternoon, Chairman Winslow and Commissioners. Regina Iori, Deputy Attorney General, Delaware Department of Justice, representing the Division of the Public Advocate.
Thank you, Chair Winslow and Commissioners. Bill O'Brien on behalf of Commission staff, and I have with me today to my right Isla Causey, the Public Utility Analyst for staff assigned to this case. I will note that Jim Geddes was engaged as lead counsel for staff in this matter and did all the heavy lifting in the case, but I am also assigned as DAG to this matter for staff. Thank you.
Thank you. I would first like to move into the record prospective exhibits that have been circulated among all of the parties. There are 10 prospective exhibits. 8 prospective exhibits that I would like to identify at this time. And at the end of identifying these exhibits, I believe I would like to ask the unanimous consent of council that they be moved into the record as follows. Exhibit JA1 is the joint application filed by the joint applicants on June 11, 2021 with attachments A, B, C, D1, D2, and E, and attachments F. Exhibit JA2 is the pre-filed direct testimony of Keith Olderwordle with Exhibit KW1. Exhibit JA3 is the pre-filed direct testimony of John Hollenbach. JA4 is the pre-filed direct testimony of James Cagle. JA5 is the affidavit of publication of the public notice of the application pursuant to this document in the News Journal and the Delaware State News on July 11, 2021. Exhibit JA6 is the affidavit of publication of the public notice of the public comment session published in the News Journal and the Delaware State News on August 18, 2021. Prospective Exhibit JA7 is the affidavit of publication of public notice of this evidentiary hearing published in the News Journal on September the 16th, 2021. And finally, Exhibit JA8 is the settlement agreement dated September 29, 2021 among the parties. I would like to ask council for their unanimous consent to move these exhibits as identified into the record. Mr. Shell.
No objection, hearing examiner Kenton.
Ms. Scott.
No objection.
Ms. Iori.
No objection.
Mr. O'Brien.
No objection, Your Honor.
Thank you, parties. Mr. Shell, you're on. Please call your first witness or identify the witnesses you would like to call.
Thank you, hearing examiner Kenton. I was going to hand off the microphone to my colleague, Mr. Backery, who wanted to make a quick remark, and then I believe Ms. Scott will have the first witness.
Very good.
Thank you.
Good afternoon. I was going to actually walk through some of the procedural background for the commissioner's benefit, but hearing Officer Kenton has comprehensively accomplished that already, so I will dispense with those comments and proceed to call our first witness. Proceed to call the witnesses for the joint applicants. And actually, I think we indicated that we would proceed with Suez's witness first and then close with the Veolia witness.
That's certainly fine. Ms. Scott.
Thank you, hearing examiner Kenton. At this time, I would like to call James Cagle on behalf of Suez, and I would ask that he be sworn, and he is participating by telephone.
Mr. Cagle,
I am here, yes.
Are you on the phone?
I am here, yes.
The court reporter will proceed to swear you in.
Mr. Cagle, please state your full name.
My name is James C. Cagle.
Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Cagle, by whom are you employed, and what is your title, please?
I am Vice President of Rates and Regulatory Affairs, and I'm employed by Suez Water Management and Services, Inc.
And how long have you held that position?
I have been with Suez since October of 2007, and I became Vice President in early 2010.
And is it correct that in connection with this particular docket that the parties have reached a settlement?
Yes.
Did you participate in the settlement discussions on behalf of Suez?
I did, yes.
And did the parties actually execute a settlement agreement in this matter that has been provided to the commission?
Yes.
Would you, for the benefit of the commissioners, could you provide us with some key features of the settlement agreement that the parties have entered into?
Oh, certainly. So to summarize the settlement at kind of a high level, The settlement has numerous provisions, including around employees and operational stability, rate stability, low-income arrearages, COVID-19 relief, affiliate interest agreements, capital plans, community benefits, and purchase accounting commitments. The agreement also addresses some estimated billing practices and some other related commitments. It also includes a most favored nation provision. To speak a little bit about each, as related to operational stability and employees, the settlement agreement includes commitments related to employment and compensation of Suez Water Delaware's personnel for a period of 18 months following the closing of the transaction, and it also includes a commitment to honor existing collective bargaining agreements. For rate stability, the agreement includes a moratorium on rate increase filings, except for the distribution system improvement charge, where Suez Water Delaware will not file a base rate case for 1 year from the consummation of the transaction. Additionally, if I might add, the costs associated with the transaction will be excluded from recovery from Suez Water Delaware customers. The agreement includes relief to low-income customers, whereby Suez Water Delaware's shareholder-funded CARES program will be expanded, with the details of that expansion to be determined in subsequent discussions with staff, DPA, and other interested shareholders. Also, once the transaction is consummated, $110,000 will be provided to Suez Water Delaware's CARES program. The agreement provides for an arrearage program where $300,000 is to be provided by Veolia for past due arrearages beyond 60 days for active residential customers. And I would note that this is incremental to any low-income household water assistance program, and that's LIWAP, or any other state-funded programs. As related to affiliate agreements, as a result of the transaction, there would be no changes to Suez's affiliate agreements, including the agreement with Suez Water Management and Services, Inc. The implementation of Suez Water Delaware's long-term capital plan through 2024 will continue, and also potential enhanced technologies, my apologies, will be evaluated. For community benefits, another provision of the agreement is an enhancement of the charitable giving program, whereby there's a commitment to spend an additional $100,000 over the next 3 years, as well as a commitment to build on and expand Suez Water Delaware's current community activities. For purchase accounting, the effects of purchase accounting will not be recorded on the books of Suez, but if there is an impact from purchase accounting, such impacts would not impact the assets or costs directly charged or allocated to Suez Water Delaware. There will also be no changes related to corporate structure at Suez Water Delaware's immediate parent level, and no changes to income tax and accounting policies and the current financial protections. Suez Water Delaware will intensify efforts to address some estimated billing practices, which relate to bills which were estimated more than 6 consecutive months, and that also includes quarterly reporting for a 5-year period beginning on January 1st of 2022, and provisions for addressing variances in bills based upon meter reads that also will benefit customers. And finally, there's a most favored nation provision, which is included to ensure that contributed benefits across all of Suez jurisdictions are equivalent.
And Mr. Cagle, I'm not sure if I heard you mention this or not, but Suez also agreed to forgo recovery of its COVID-19 regulatory asset. Is that correct?
Oh, yes, that is correct.
In connection with this settlement, is it your opinion that the settlement agreement is a result of an arm's length transaction amongst the parties?
Yes, the settlement agreement was a product of lengthy and good faith negotiations amongst the party and represents a fair result for Suez and its customers. The settlement also avoids costly litigation over the transaction. I believe that the Commission's adoption of the settlement agreement is in the public interest.
And as part of the proceeding before the commission, there are certain statutory requirements that the commission needs to confirm that are being met here. Can you provide your opinion as to whether the transaction is for a proper purpose, consistent with the law, and consistent with the public interest?
Yes, while I'm not an attorney, I do believe that the transaction is for a proper purpose and is consistent with law and with the public interest. I mean, the transaction will join two companies which are truly world leaders in water treatment and distribution services. As a result of the transaction, significant customer benefits will be realized, including but not limited to investments in infrastructure as needed to maintain and improve service. We'll work to improve customer service, and there's a commitment to contribute additional funding for customers to address arrearages caused by the COVID-19 pandemic.
Thank you, Mr. Cagle. Is there anything else you would like to add at this time?
No, I believe that's it.
Thank you. Mr. Cagle is available for cross-examination or any questions from the commission.
Mr. O'Brien.
No questions, Your Honor.
Ms. Iori.
No questions.
I will ask the commissioners for questions they might have at a later time, but of course they're free to interrupt anytime they'd like to ask questions. Mr. Winslow.
Mr. Cagle, this is Dallas Winslow.
Yes, sir.
We miss you. How come you're not here in person?
Well, since we're on the record, my daughter will get a kick out of this. She's getting married, so I am going to be attending her wedding, which is on Friday afternoon, and so I'm sure everyone remembers either their wedding day or their children's wedding day. It's a momentous occasion.
Well, congratulations to you, and I wish you good luck in your French lessons.
Yeah, thank you.
Mr. Shell.
I'll turn the microphone over to Mr. Bakri, who will call Veolia's witness.
Thank you. We have Keith Oldewirtle appearing for Veolia, also telephonically. Mr. Oldewirtle, are you on the line?
Yes, I am on the line.
Good afternoon. Oh, I'm sorry. Ms. Oldewirtle, do you hereby... Oh, thought I did that.
This is the court reporter. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Oldewirtle, please state your name and business address for the record.
And my name is Keith Oldewirtle, and my business address is 53 State Street, 14th floor, Boston, Massachusetts, 02109.
Can you please identify your employer and current position?
I'm the Executive Vice President and Chief Operating Officer of Veolia North America, Inc.
And what are your duties and responsibilities in your current position?
I'm responsible for overseeing the North America municipal water business line at Veolia North America. These responsibilities include overseeing operations, environmental compliance, safety, financial performance, and customer service.
Can you briefly describe Veolia and its operations?
Veolia is an international organization based in Paris, France, and offers water, wastewater, waste management, and energy services across the globe. Veolia employs over 178,000 people located in 55 countries. From a financial perspective, Veolia maintains a stable credit rating and has annual revenues of over $31.2 billion.
And Mr. Oldewirtle, did you previously provide testimony in this proceeding?
Yes, I submitted direct testimony, which was filed in support of the joint application.
Mr. Odoberto, can you give a brief description of the transaction that is the subject of this application?
Yes. On February 28th of 2021, Veolia announced an initial tender offer to acquire a majority of Suez's share capital. On May 14th of 2021, Veolia and Suez entered into a combination agreement through which Veolia would acquire control of Suez and Suez's utility subsidiaries in the United States, including Suez Water Delaware. The transaction is expected to close during the fourth quarter of 2021.
Are you familiar with the settlement agreement that was prepared among the parties of this proceeding?
Yes, I was involved in the settlement discussions and reviewing the settlement agreement.
Do you believe the settlement agreement is in the public interest?
Yes, I echo the comments of my colleague Jim Cagle on the settlement agreement. I believe the overall transaction, as modified by the settlement agreement, includes many benefits for the Suez Water Delaware and its customers. The transaction will combine two international water and wastewater companies, which are expected to have positive effects for Suez Water Delaware. And as detailed in Mr. Cagle's testimony, Veolia is committed to providing several Delaware-specific benefits, such as arrearage relief, low-income assistance, charitable contributions, and a rate freeze.
Thank you. If the transaction and related settlement agreement is approved by the Commission, is it important to Veolia that Suez Water Delaware continue to provide reasonable, safe, and reliable service to customers in Delaware?
Yes, and Veolia intends for Suez Water Delaware to continue providing excellent service to its customers after the transaction occurs. The transaction is occurring at many levels above Suez Water Delaware in the overall corporate structure. However, Veolia is committed to helping Suez Water Delaware and all of its subsidiaries remain successful. Veolia believes the combination of Veolia and Suez will provide long-term benefits throughout the corporate structure.
Do you have any other comments you would like to make today before the Commission?
Yeah, I would just like to thank the Commission and its staff for all of its efforts to process this matter within the proposed time frame. I would also like to thank the Division of the Public Advocate for diligently and efficiently participating in discovery and settlement discussions. After the transaction closes, we look forward to working with the Commission in the future and perhaps presenting a state of the company address to update the Commission on the integration of Veolia and Suez.
Do you have any further comments?
No, thank you.
Mr. Odoberto is now available for any questions or cross-examination.
Mr. O'Brien?
No cross, thank you.
Ms. Iori?
No questions, thank you.
I just have one question for the witness. This transaction, as you described and as the application describes, has many parts to it in several states and in actually several countries. Could you tell us just very briefly whether the approvals that are required from the various other states and the international approvals are still on schedule? Do you see any roadblocks that are insurmountable between now and the potential closing at the end of the year?
Yes, at this point in time, we are proceeding with all of our required approvals. We have obtained several of them already. We are in responding to discovery questions and actively engaged in ongoing settlement discussions in the other states where the utilities in the U.S. The international approvals are proceeding, and to my knowledge, everything is proceeding on schedule without any significant issues identified.
Thank you. Last question. How many employees does Veolia North America have in North America? I know there are several employees you talked about worldwide, but how many customers do you have in North America?
So I will speak to our municipal water business in North America. We operate approximately 150 different systems for approximately 120 customers, providing water and wastewater operation and maintenance services. Veolia North America has approximately 7,500 employees engaged in waste business, energy business, and water total.
You said 120 employees, or excuse me, customers, you mean 120,000?
No, I'm sorry, 120 municipalities that we have a contract with.
I'm sorry, about how many customers do you serve? If you know.
Yes, I do not have that information right offhand.
Not critical. Do you have any further witnesses, counsel?
No hearing officer, Mr. O'Wordle is the only witness appearing for Veolia today.
Mr. O'Brien.
Thank you, Your Honor. Staff does have one witness, and I would call to the stand Isla Kazi.
Please raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Ms. Kazi, please state your name, business address, and current occupation.
My name is Isla Causey. My business address is 861 Silver Lake Boulevard, Suite 100, Dover, Delaware 19904. I am a public utility analyst for the Delaware Public Service Commission.
And briefly describe your role in this proceeding.
I was assigned as an analyst on behalf of staff for this proceeding. I have been actively involved in this case and have been reviewing all the correspondences, which includes the company's application, discovery, and pre-filed testimonies since it was filed in June 2021.
And did staff retain the expertise of consultants on behalf of staff in this matter?
No consultants were retained for this case.
In connection with this matter and as an analyst, did you prepare any written testimony in this case?
No. After a preliminary review of the application and a discussion of the potential issues, the parties decided that it was in the best interest of everyone involved if we tried to reach a settlement of the potential issues and determine the best and most feasible way for Veolia to acquire Suez. So there was no written testimony filed by staff in this case.
And Ms. Causey, were you involved in negotiations that led to the proposed settlement agreement, which has been entered into the proceeding as Exhibit Number 8?
Yes, I have been involved in all the settlement discussions, including the settlement conference and subsequent email exchanges among the parties.
Ms. Causey, do you agree with the description of the terms of the proposed settlement agreement?
Yes.
And do you support the proposed settlement agreement's adoption by the Commission?
Yes, I do.
And without repeating what has already been said, is there anything you would like to add regarding the settlement agreement that has been entered as Exhibit 8 in this proceeding?
I agree with all that has been said in support of the settlement. In addition, I would like to highlight one item included in the settlement agreement that staff believes is important. Item 21 states that before implementing any new programs or projects relating to certain technologies, Veolia will perform a cost-benefit analysis and share such analysis with staff and DPA prior to any implementation. I believe this item resolves some of the issues that were brought forth in the 190615 case regarding Suez implementing new programs or projects without a cost-benefit analysis.
So in summary, why do you support the settlement agreement?
First, the cost-benefit analysis will give staff and DPA insight into new programs or projects before they are implemented by the company. Second, a substantial amount of discussions among the parties has taken place in attempt to resolve the issues in which the parties disagreed upon. Fortunately, each party was actively engaged throughout the settlement discussions as they progressed. Furthermore, it is in the public interest to avoid additional costs associated with evidentiary hearings and post-brief hearings, which can be a significant cost, which are ultimately passed to the company's ratepayers.
So, Ms. Causey, in your opinion, would the commission's adoption of the proposed settlement agreement be in the public interest?
Yes, for the reasons previously stated, staff believes the proposed settlement agreement is in the public interest and balances the interests of all parties in this proceeding. I believe the commission should adopt the settlement agreement.
Is there anything else that you believe that should be brought to the attention of the hearing examiner or the commission at this time while considering the settlement agreement proposed in this case?
I do not.
Thank you. Ms. Causey is available for further questions.
Mr. Bakari, do you have questions?
Just one brief question, if I may. There was a mention of no testimony being provided, but staff did propound discovery in this docket. Is that correct?
Sorry, could you repeat that?
Staff did provide discovery that was answered by the joint applicants. Is that correct?
Staff, yes.
Thank you.
Do you have any further questions, Mr. Bakari?
No, thank you.
Ms. Iordi?
No questions.
Mr. O'Brien, do you have further witnesses?
No, that's staff's case, Your Honor. Thank you.
Ms. Iordi?
Thank you. I'm hearing Examiner Kenton. The public advocate calls Andrea Moucher to the stand and asks that she be sworn.
Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Ms. Moucher, would you please state your name and business address for the record?
Yes, Andrea Moucher, 29 South State Street, Dover, Delaware, 19904.
And by whom are you employed?
The Delaware Division of the Public Advocate.
What is your position with the DPA?
Public Utilities Analyst.
What are your duties and responsibilities in that position?
Primarily, I act as case manager in all dockets opened by the Public Service Commission and in which the DPA has intervened. In that role, I am responsible for review and analysis of utility filings and discovery, retention and supervision of expert witnesses, and participation in the development of positions taken by the public advocate.
As part of your duties and responsibilities, did you review the application of Veolia Environment S.A., Veolia North America, Inc., Suez S.A., and Suez Water Delaware, Inc., pursuant to Delaware Code Section 215, pertaining to an indirect change in control of Suez Water Delaware, Inc.?
Yes.
Did the public advocate engage any outside consultants to assist with the review?
The DPA has a contract with Technical Associates, Inc. to provide assistance with non-rate case-related issues that may come before the PSC. In this case, Mr. Glenn Watkins performed a high-level review of the filing and discovery responses.
Did Mr. Watkins identify any areas of concern as a result of his review?
No, he did not, and the DPA did not ask him to file testimony in this case.
As the DPA's witness, you are aware that the parties reached a settlement in this case, correct?
Yes.
Do you believe that the proposed settlement is consistent with the public interest?
Yes.
Why do you believe that?
First, the continued operational stability of Suez is essential for its customers, and the proposed settlement provides that Suez management, jobs, employee compensation and benefits, and other contractual rights and obligations will remain unchanged for 18 months post-transaction. Additionally, all collective bargaining agreements currently in effect with Suez's unionized workforce will be honored. Second, to ensure rate stability, the joint applicants have agreed not to seek any increases in base rates for at least 1 year. There is also an agreement to forgo recovery from Suez's customers of all direct and indirect costs relating to the transaction. Third, affordability of water service is a significant concern of the public advocate. To that end, the joint applicants have committed to contribute $110,000 into the Suez Cares Fund, which assists payment-troubled customers. In recognition of the impacts of COVID-19 on its customers, the settlement agreement also contains the commitment from Veolia shareholders to contribute $300,000 to reduce total residential customer arrears that are more than 60 days overdue. If total residential arrears are less than $300,000, the excess will be contributed to Suez Cares program. This $300,000 is in addition to any state or federal COVID funding assistance made available to customers. Importantly, neither Suez Cares donation nor the $300,000 for arrears reduction will be recovered from Suez's customers. Suez also agrees to forgo future collection of any incremental costs already booked to the Commission-approved regulatory asset for COVID costs. Fourth, Suez will continue with its long-term infrastructure improvement plan through 2024, a copy of which was previously filed with the Commission. Prior to implementing any advanced technologies, Suez will inform Commission staff and the DPA as to the costs and benefits of such technologies. Further, if such technologies are adopted and replace existing systems, Suez will not seek recovery from ratepayers of any stranded costs. Relating to community benefits, the joint applicants pledge an additional $100,000 over the next 3 years in support of community, charitable, or conservation and sustainability organizations impacting Suez's service territory. This is in addition to Suez's current level of community investment of approximately $51,000. These amounts will not be recovered in rates. As with an Exelon merger, the DPA was insistent that Suez's ratepayers be financially insulated from this transaction. None of the impacts of purchase accounting will be recorded on Suez's books and records so that the historical financial accounting at Suez is maintained. If, however, purchase accounting does impact Suez's books, Veolia agrees there will be no impact to the assets and costs directly charged and allocated to Suez. Further, no goodwill or other fair value adjustments will be recorded. Additional transaction-related commitments are detailed in the settlement agreement, all with the intent of protecting Suez's current and future customers. Through its handling of customer complaints, the DPA became aware of multiple Suez customers receiving estimated bills for water service, some of which covered a significant period. As part of the settlement agreement, Suez has committed to resolving estimated accounts and ensuring that no customer receives estimated bills for longer than 6 consecutive months. For a period of 5 years, if an actual meter reading finds that a customer whose usage was estimated 6 months or longer has been undercharged, Suez has agreed to forego the collection of any underpayment amount and not recover those amounts and rates. All overpayments, of course, will be refunded to the customer. Finally, the settlement agreement contains a most favored nation provision whereby if the aggregate dollar amount provided by Veolia in another jurisdiction is materially more beneficial than the terms of this settlement agreement, then Veolia will increase the dollar amount contributed to customer benefits in Delaware to reach an equivalent per customer contribution. In conclusion, I believe the proposed settlement agreement in this case is consistent with the public interest, provides material benefit to Suez's customers, and contains significant financial protections for those customers. Additional litigation in this matter is unlikely to generate a substantially different result and would unnecessarily expend the limited resources of the DPA, staff, and the Commission. For these reasons, I urge the Commission to approve the proposed settlement agreement.
Thank you, Ms. Moucher. Ms. Moucher is available for cross-examination by the parties or any questions that the commissioners may have.
Let me start with Ms. Scott. Ms. Scott, I omitted you with respect to potential questions from the from the staff witness. Do you have any questions for either of those witnesses?
I do not, thank you.
Sorry, Ms. Stout.
No problem.
Mr. Bakari, do you have any questions of the witness?
No questions, thank you.
Mr. O'Brien?
No questions, thank you.
Thank you.
The DPA has no further witnesses.
Took the words right out of my mouth. Two quick things. First of all, are there any members of the public here who have an interest in this case who would like to testify or make a comment to the Public Service Commission? Any members of the public are now encouraged to speak up if you are here and would like to be heard. I hear none. With that having been said, Mr. Winslow, I turn it over to you and your commissioners for further questions and for act on the prospective application, and there is a form of order if the commissioners so decide to approve it.
Thank you, Mr. Kenton. Very well done. Commissioners, do you have any questions at all? Commissioner Gray?
Yes, just two questions. The way I read the structure of the organization, it still will operate as Suez, even though it's being acquired. Is that a good assumption?
That's
Well-
correct. There are no current plans to change the name to of the Suez Water Delaware Incorporated entity. If, as part of this transaction, if at any future point there is a change to the name, the companies will present the proposal to the commission and work through the appropriate regulatory process required for that type of change.
Okay, and one other question is more financial from the balance sheet. I'm usually concerned about the debt-to-equity ratio before and after the transaction.
That concern was also expressed by both staff and DPA as part of our discovery process. And I will note, and then perhaps Jim Cagle may be able to answer this question better than me, but there are several existing protections in Suez's current debt covenant that address the debt and equity ratios. And as part of this transaction, Veolia is not changing the Suez money pooling agreement. And so those protections will remain in place as they are today.
No further questions, Mr. Chair. Thank you very much. Great presentation.
If there are no further questions, Commissioner Drexler.
Yes, I'd like to make a motion to adopt proposed order number 9894, adopting the settlement agreement.
Second the motion?
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
4-0 and 1 absent. Gentlemen, lady, Ms. Scott, and everyone, thank you so much. Best wishes to Veolia, and we'll see you for the state of the company hopefully sometime soon.
Yeah, right.
Thank you very much.
Thank you very much.
Okay, next on the calendar, we have public comment. Would all the members of the public who wish to make public comment, please come forward. Looks like there's not a rush to the front, so we don't have anybody to make public comment. And we do have one more important matter, and I'll turn it over to our Executive Director, Mr. Hardikin.
Thank you, Chairman Winslow and Commissioners. Staff did retain Dr. Paul Sukevich, who is a former PJM economist, to help us evaluate whether the fixed resource requirement option makes sense for Delaware. This concerns Delaware potentially leaving the PJM capacity market as a result of the recent MOPR order. So, Dr. Paul, are you with us?
Yes, I am. Can you all hear me just fine?
Yes, thank you. And the commissioners do have your presentation, so I'll turn things over to you.
Thanks, Matt. Thanks for the kind introduction, and for the commissioners, for those of you who I have not met. I'm Paul Sukevich. I'm the president of EQ Policy Associates based in Gainesville, Florida. And as Matt Hardigan mentioned, I'm the former chief economist of PJM Interconnection. And Chairman Winslow, it's great to see you again on the live stream, although you can't see me. It's been too long, my friend.
I'm better off for that.
So if we could just flip to the second slide. And so I've got two slides of really summary conclusions, and I'll just run through these really quick and cut to the chase given the length of the meeting to this point this afternoon. I think one of the big things for Delaware is that the current rules for the fixed resource requirement, or FRR, are not well defined enough for Delaware, where Delaware as a state has both municipals and co-ops that are not jurisdictional with PSC, as well as Delmarva Power and Light, which is jurisdictional, plus also being located in constrained locational deliverability areas and having retail choice. All of those things together really aren't contemplated completely with respect to the FRR alternative. And so the rules themselves just aren't well defined enough for Delaware to even reasonably make that decision if it wanted to, just because the rules are incomplete and it would lead to a lot of litigation at FERC. Obviously, the second big one of this is being in a constrained locational deliverability area. As one of the big omissions in the rules is there is no way to allocate transmission capability across congested interfaces to Delmarva Power and Light as a distribution company and load-serving entity within Delaware in order to make that happen. So that's going to be also would also be very problematic. There are rules to allocate transmission capability within the RPM auction itself in terms of capacity transfer rights, which reduce the overall cost to customers in Delaware being in a constrained locational area, but no such rules exist for the fixed resource requirement. And the third thing is if we think about being transmission constrained and with some of the retirements that are taking place, the resources that are in the new services queue that are located in Delaware, and I'm thinking the retirement specifically of Indian River 4, which is 410 megawatts down in southern Delaware. Delaware is going to probably fall short of the needed resources being in a constrained area to meet the requirements to be in the fixed resource requirement at some sort of reasonable cost. So you add just the supply and demand and transmission conditions along with really ill-defined rules, even if Delaware really wanted to push toward a fixed resource requirement, it would be all but, I won't say impossible, but it would be an extremely heavy lift and would encounter a lot of potential litigation at FERC. So if we get down to the fourth point, and this is getting to the current regulatory environment in Delaware, is that the fixed resource requirement historically has never been used in a state or zone where there's been retail choice. In fact, in Ohio, where there was retail choice implemented, entities like AEP Ohio and Duke Ohio left FRR and went into the capacity market for obvious reasons. This is going to counteract a lot of the effects of retail choice. It's going to limit the ability of those retail service providers to hedge their capacity costs through whatever arrangement they may choose, and they would be stuck with those higher capacity prices. Or depending upon state law, and this did happen in Ohio for a short period of time, there was no means by which to actually charge customers for the FRR costs, and so those costs under the PJM tariff reverted to the RTO cost. To give you an example financially of how that worked out, and this is all in the longer paper, by the way, is that the approximate cost is about $430 per megawatt day, which is, let's say, close to 9 times the most recent RTO price that just cleared in the 22-23 BRA. But in this particular case in Ohio, this was a decade ago, and the price was $16 one year and $27 another year. And that's what those retail choice customers paid for capacity. So that just really, so people were fleeing the FRR entity, getting out from under the capacity charges. There had to be changes in state law in order to rectify that. The other thing that I think is a big deal is that if there's questions, by the way, I'm sorry, I haven't taken a breath yet. I'll stop after this fifth point and ask if there are any questions before I move to the next slide. The FRR regime does nothing to help Delaware in particular meet its RPS goals. Delaware, while the beaches are beautiful and remind me of here at home in Florida, I love Bethany Beach for the record, it's not going to do anything to further the RPS goals of the state because Delaware isn't endowed with onshore wind Solar is possible, but it takes an awful lot of land to do solar. And then there's just not a whole lot of new renewables in the interconnection queue itself. And so, Delaware has consistently, as part of PJM and depending upon that joint and regional dispatch and planning process, has benefited greatly in terms of meeting its RPS requirements by effectively paying for renewables in other parts of the footprint that are much more cost-effective for Delaware customers, and just paying for the rights to have those resources dispatched and displacing emitting resources on an economic basis. So I'm going to stop there if there are any questions, and then I can move on to the next slide. I'm hearing none. Okay, thanks, Matt. Let's go on to the next slide here. So these are, this is getting into some of the cost issues here and reliability issues. One of the things about the fixed resource requirement is going to be under capacity performance. Almost by default, all of the risk will be shifted to the load under the FRR. In this case, it would just be the Delmarva Power and Light customers, not the municipal and cooperative customers in the state. And that's because the default under FRR is that the FRR entity will be responsible for those performance penalties, unless into the contracts with FRR resources, there's something written in that those resources would take on the risk of performance compliance and all the penalties and potential bonuses that would also raise costs. This effectively shifts a lot of the risk back to customers that had been shifted onto generators in the PJM framework. There's no way to actually make this any larger. Delaware being on the Delmarva Peninsula, it would be impossible to join Maryland because most of Maryland, but for the Eastern Shore, is in Southwest MAC or in the case of Western Maryland in RTO. And there's no transmission links directly between Delaware and that part of the PJM footprint. Then there's Virginia, the small part of Virginia with Accomack Electric Cooperative on the peninsula, is electrically separated from the rest of Virginia, which is in RTO. Again, no direct transmission links there. So even a multi-state RTO, unless you went with Pennsylvania and New Jersey, if they chose to go that route, would be almost impossible to actually pull off because of a lack of transmission constraints, or lack of transmission connections, excuse me. So what would the cost be? And I'll get to the details, but the long and short of it is that the incentives for resources, once they know an entity is going to be an FRR, is there's a holdup problem. Those resources can hold the load looking for an FRR hostage. You need us. You've committed to FRR. You will need to take us, and we can name our price. And so if you're thinking about the costs, and if we're thinking about moving toward more renewable resources, forget the fact that there's very little in the queue. Let's just do a thought experiment. Let's say it was all tracking solar photovoltaic resources. That would at least cost 2.5 times the amount that Delaware is currently paying today for resource adequacy. If you're looking at the cost of offshore wind, and I mean the cost that PJM has cited for offshore wind, not the actual cost being paid by Maryland and New Jersey, which are actually far greater than the PJM benchmark for the minimum offer price rule, you're talking about 21 times the cost of what Delaware customers pay today. So that doesn't even seem feasible financially or politically. Even if Delaware decided to forego clean resources and just went with an all-combustion turbine or combined cycle fleet, and again, there's questions about whether there's enough gas pipeline capacity to deliver that gas into the Delmarva Peninsula for such an activity. Even there, those portfolios are going to be more expensive than what, again, the Delaware customers pay today. But at the end of the day, since we started this work way back when, things changed recently. On September 29th, the PJM filing with the new Focus MOPR went into effect by an operative law. No FERC order, split commission 2-2. And so right now that's the law of the land. And so a lot of the questions around FRR have essentially been answered at that point. So we could go to the next slide if there are no questions. I've talked about the history, so I'm going to skip that one. And if we go to slide 5, actually, Matt. Just to give the commissioners a sense, for those who are not intimately familiar with the PJM system and the transmission system in the eastern part of PJM, what I've got here in slide 5 is the map of the eastern mid-Atlantic region, which encompasses New Jersey, southeastern Pennsylvania, Delaware, and the Maryland Eastern Shore, and obviously the one county in Virginia at the very end of the Delmarva Peninsula. But what's interesting, again, if we think about this, and I'd like to thank staff, both Matt Hardigan and Dimitar Kajahurov, for their help in getting DPL to provide some more granular data than is otherwise publicly available to us. We were able to discern from some of that the Delaware peak load that would have to be served in the FRR for Delmarva Power and Light would only be 65% of Delaware's total peak load. And what's even more interesting, and you get into details in the report, is that if you look at where the load growth is in Delaware, the load growth is not in the Delmarva service territory. The major load growth is actually with the municipals and co-ops within Delaware going forward. So, they're going to be a much more crucial player in terms of climate policy and making renewable choices, which many of them already are, than would DP&L be in this particular case. So one other issue that we would like to deal with the FRR, and again, this is a quick summary, and these tables appear in the paper, but I think one of the things, if we go to slide 6, we're thinking about those transmission constraints. As part of the PJM reliability pricing model or capacity market, transmission-constrained areas such as Delaware and New Jersey actually have a higher multiplier over the peak load for the amount of capacity that's needed. And that also accounts for the available transmission capability to move resources from outside of Delaware into Delaware to serve the Delaware load. And so in that top table on slide 6, you see that multiplier, that implied multiplier, which one can just do simple math from the base residual auction planning parameters, and the forecast pool requirement for RTO, which is the percentage of capacity over the peak load in unforced capacity terms, that is accounting for expected forced outage rates of resources, is only about 8.6%. If you look at Eastern MAC as a larger region, as I showed you on the previous slide, it's just over 20%. If you look at DPL South, which is all of Delaware south of the Delaware Canal, that's going to be 36%. So the FRR rules are such that if you're an FRR entity, you only have to purchase over your peak load the forecast pool requirement. And so what that means is that the reliability requirements actually go down. So FRR actually reduces reliability to some extent for Delaware, if Delaware would go down that road. So not only would the cost be higher, reliability actually would be lower in terms of resource adequacy for the state of Delaware here. Let me go to the next slide. And this is, I think, where all of the conflict really is occurring here in PJM, or has been occurring and probably will continue to do so through litigation, is thinking about the environmental goals of states versus what is capacity and resource adequacy in PJM. And there are different ways to meet the environmental goals. One is, as Delaware has pursued, is an aggressive renewable portfolio standard, but where Delaware customers can buy RECs from outside the state, where those resources are lower cost to build. They can produce more renewable energy, whether it's because they're in a sunnier spot in the footprint or because they're in a windier spot in the footprint, or land is cheaper in that part of the PJM footprint. But what's important with renewable portfolio standards and renewable energy credits is from an environmental standpoint, it does not matter where those renewables are at. They're just still displacing emitting resources, rather than saying it must be built here. almost as a protectionist sort of policy. So the location doesn't matter. Capacity, location matters a lot. It helps to have the capacity close to you rather than relying on the transmission system. RPSs, we know renewable resources are not controllable. They're intermittent and variable. But capacity, you have to depend on it. You need it when it's there for a reliability situation. So these are very different things, and in fact, they're quite orthogonal to one another. And so, that's why the one conclusion is that RPSs, Delaware can still easily meet its RPS with or without an FRR plan. They can still buy renewable resources, or customers can still buy renewable resources from out of state at this point. Whereas for resource adequacy, much of that capacity has to be in Delaware. Yes, there is some dependence upon the transmission system, but at the end of the day, that capacity has to be in Delaware or deliverable to Delaware, whereas the RPS does not, and renewable energy credits do not. So that's a really important thing, is by not going FRR, there's no sacrifice in environmental policy the way it currently is in the state of Delaware. If we could go to slide 8, and I'm almost done. I've only got this and one more slide to go over, and I apologize again for being like a Microsoft operating system, expanding to fill the space that's available. If we think about the estimated baseline cost, and what I did is I took the 22-23 base residual auction that was run earlier this year for, again, just Delmarva Power and Light customers in Delaware. Remembering again that municipals and co-ops are not jurisdictional to the commission. That annual price is estimated to be just north of $68 million a year for the Delmarva Power and Light customers for capacity. Remember, the price in the constrained LDA, it wasn't RTO, but it was only $98 a megawatt day. In fact, that is the lowest effective price Delaware has faced in the PJM capacity auction ever, all time. It's the lowest price that Delaware has faced. Why is that? A lot more resources that are coming online, newer resources, are lower cost overall. They have lower going forward costs to keep them up in particular. But the other thing, too, is that PJM is doing a better job with load forecasting. Hopefully the 3-year ahead load forecast error will be going down. We also are seeing that as we're seeing a turnover in the generation capacity in PJM, especially the controllable capacity, the movement from a lot of old coal, old oil and gas steam to newer combined cycle units, those units are far more reliable. And so you don't need as many megawatts of capacity overall. And so that's helping drive prices down. But if you look at that price versus what the net cone would be for different technologies, whether it's a combustion turbine in Eastern MAC or DPL South, the PJM benchmark for combined cycles for the minimum offer price rule, the MOPR prices for solar tracking or fixed solar resources, offshore wind, storage, and then I included at the bottom, and I apologize, and this is probably a bit of a sore spot for a lot of folks in the state, but the Bloom fuel cell and the implied capacity cost of that Bloom fuel cell based on the data that they submit to the Delaware Commission every year in terms of what they're earning in the energy market, what their gas costs are, and what the contract pays them. It's quite a bit higher. And again, lower reliability. And so let me conclude with the last slide, sort of the punchline in the total costs on slide 9. And so effectively, I'm not going to concentrate. We can talk about millions of dollars, but let's talk about ratepayer impact, which is going to be the second table at the bottom there. The costs above the baseline, okay, so above the cost from the 22-23 BRA are all higher than the baseline. And so if we think about what the baseline cost is, it's more or less about $875, $880 a megawatt hour for capacity on the customer bill, assuming a residential customer consumes about 1,000 megawatts a month. If you look at these different options, if it's all combined cycle, it's not too far above the baseline. Again, assuming we could actually build natural gas pipeline capacity. If we look at storage, again, you still need resources close by. Storage may actually prove to be something that might be helpful here. But if you look at some of the others, the offshore wind would add $179 a month to customer bills, over and above what they're paying today. That's a month, not per year, per month. Even if you're looking at solar fixed and solar tracking, you're talking about $31 or $12 a month extra, over and above what people are paying now. And it's my understanding from staff with the Bloom Fuel Cell that the impacts of just that alone, just a few megawatts of fuel cell energy alone, today are probably costing anywhere from $3 to $6 a month extra for customer bills. So certainly FRR doesn't make a whole lot of sense. There are other costs that I haven't even mentioned here, such as transaction costs, institutional costs, developing new institutions, bringing in additional staff, hiring additional consultants to help administer a potential competitive procurement, search costs if you're doing bilateral contracting. All of that would just add costs, and those costs are impossible to quantify at this point. So with that, if there are any questions, I am happy to take them, but I wanted to thank again the commission and the staff for the opportunity to work with them on this. And I think this sort of bears out, kind of what we're seeing decisions other states are finally making after all of the heat and fire surrounding FRR here. So with that, I'm going to conclude and open it up to the commission. Thank you.
Paul, that was just terrific. Thank you so much. And I'm also jealous. Gainesville's a nice place. Although in Lewis, where I live, is pretty nice too, Paul.
Mr. Chairman, I'd be happy to come and visit you and lose anytime.
Okay. Does anybody have any questions? Because this gentleman knows his stuff. Timmy? Okay, Mr. Hardigan.
Thanks again, Dr. Paul. We really appreciate that. So Chairman Winslow and Commissioners, I did want to thank you all for being here in person. It's not only great to see you, but I think for contested issues like we had today with Delmarva, those are better resolved in person, in my opinion. So thanks again for making the effort to be here. Our next meeting will be October 27th, and we'll see you then.
Thanks, everyone. We're now adjourned.